Law is this. Good evening and welcome.
All right, Brian, excellent coverage. With me today, Jeffrey Wolf, criminal defense attorney. Jeffrey, let me ask you a question. How is it going to work with the jurors? Pre-COVID, this testimony came out. They're not going to be able to listen to the witness again, but the judge is going to allow them to have a transcript of the testimony. But does this affect the case at all in your mind?
Yeah, I certainly think it does, and it's highly unusual. Obviously, a lot of unusual things are happening in courtrooms during COVID. But what you usually are going to see is the jury's going to get one bite at a witness because they don't want anything to bolster it or have it come in as a secondary, extra hearing of it. And to be able to go and read a transcript of one testimony, but not the others, is going to give undue weight to that testimony. And that's why they like routinely avoid this. Jurors all the time ask for a transcript of what somebody has said, and the judge routinely tells them they have to rely on their memory. And so because of what COVID has done to this trial, that they're going to have that for this testimony is a huge problem.
Who do you think it affects more here, the prosecution or the defense?
I think it affects the defense more because obviously this witness is not a friendly witness for the defense. This is somebody coming in to testify against his brother, which is very persuasive. And in order to basically keep him from having to come back in, they're going to allow the jury to hear his testimony again. That's not something any defense attorney wants to have happen. You want to get that bad witness off the stand and move on. And now, back in the jury room, they're going to be able to read it as much as they want.
I wonder, though, Jeffrey, if the prosecutors are looking at it like, look, this was one of my witnesses. This is one of the first witnesses I put on. This is the one I wanted the jury to see. And now it's reduced to just a transcript. Could there be an argument that it hurts the prosecution that way as well?
I mean, I think there could be, and I think the prosecution will make that argument when this issue likely comes up on appeal if there's a conviction, that it cut both ways here. But the reality of the situation is the jury heard this testimony and now they get to read it again. It's
Mhm.
just beyond the pale.
Yeah. It's a really good point you're bringing up that judges typically tell them rely on your memory and not necessarily on a transcript. So, but this is what we deal with the COVID situation. So, Jeff, I got to ask you this. This is another one of these witnesses, and I don't know if you had an opportunity to listen to all the testimony before, but the prosecutor was sparring with left and right over numerous issues. But how much does this move the ball forward for the prosecutor, this kind of testimony that supposedly he was in the LA area when Ms. Berman was murdered?
Well, I think it's really important testimony because it's the first person that actually puts him in LA. That's something they've had a really tough time connecting because he's been really good at covering his tracks. But the problem is that now she ends up being the wife of his lawyer, who then comes in the next day and says, "Oh no, she made a mistake. And I promise you, I know this more than anyone else does. I'm his lawyer. I know when I was in contact with him and when I wasn't. My wife made a mistake. She apologizes, but it just kind of muddies the water for their first real ability to tie him to crime, which they had to get it.
Yep. A little bit of an audio problem there, Jeff, but let me try to throw this one out there with you real quick. A lot of commenting, this is just from the practice side, that a lot of hearsay is coming out. That is out of court statements that are being introduced in court through other third party witnesses to prove the matter being asserted. Do you have a viewpoint on that with respect to this trial? Because there's a lot of that happening here.
Yeah, there is a lot of that happening, and it tends to happen in older cases because witnesses are less available. And so you have declare unavailable things decided, and then certain hearsay comes in because people are dead or gone, and that can cause a non hearsay reason for it coming in, the effect on the listener. Or, like I said, declaring unavailable is a big one. You're going to get a lot of hearsay coming in when the person who said it is not available to come testify. Then you're going to be allowed to use the hearsay because there's no other way to get it in. So when you're looking at an old case, in this case, what was never really a cold case, but decades old alleged murder here, you're going to see some hearsay by the virtue that some of the witnesses are not going to be available when the case goes to trial 30 years later.
Yeah, and that's a great point, Jeff. And we have these evidence rules, and they tell you what hearsay is, and then of course there's about 1,000 exceptions to the hearsay rule, like an excited utterance or a statement given to a medical provider, things of that nature, because they're deemed inherently reliable, even though they're hearsay statements. You mentioned declarant available and declarant unavailable, so I know from listening to you say that that you, my man, know your evidence rules. Explain that a little bit more, because we have a lot of true crime aficionados here and may not know the distinction between the admissibility of evidence when a declarant is available versus when they're not.
Right, absolutely. So when you're talking about the rule of hearsay, it's a very complex rule that breaks down into multiple categories. The first thing you have to determine is this actually hearsay, or is it being used for a purpose other than the truth of the matter asserted? If it is being used for the truth of the matter asserted, then there's one set of rules for when the declarant is available and one set when they were unavailable. And then both of those have a bunch of exceptions that fall under them for when they're going to be allowed. And the exceptions for a declarant unavailable are much looser than when the declarant is available, because those are the things that you're talking about: effect on the listener, medical diagnoses, learned treatise, things like that. But when you look at the declarant unavailable, there's going to be a lot more availability to get that evidence in, because otherwise a witness dying is the end of their evidence. And that is something that courts are hesitant to have happen, because as we know, the longer you run, like Robert Durst is alleged to have done in this case, the more likely it is that your witnesses are going to be unavailable. And then you come in and say, well, hearsay, sorry, I was able to run for long enough that they all died. And that's not really what the courts are hoping to have happen.
Professor Jeffrey Wolf taking us to law school today, my man. Great explanation. I'm being told by the producers that we're probably going to be going live in the Durst trial. So don't go anywhere while we take this short break.